A Charlottesville judge ruled on Wednesday that a Virginia statute protecting war memorials does apply to the city's statue of Robert E. Lee, but that a lawsuit against the city does not sufficiently argue that the statue is indeed a monument to the Civil War. Judge Richard E. Moore also will not order the city to remove the tarps placed this summer on the Lee statue and the statue of fellow Confederate Gen. Thomas Stonewall Jackson, despite concerns about potential damage to the statues. Charlottesville Circuit Court was full Wednesday as both supporters and opponents of the Lee statue waited to hear if Moore would allow a lawsuit objecting to the removal of the statue to proceed. The lawsuit was filed in March after the city council voted to remove the Lee statue, citing it as a symbol of racism. In a written ruling issued Wednesday, Moore said it is clear the Lee statue would fall under Virginia Code 15.22/1812, which states that our locality may erect monuments or memorials for any war or conflict, including the Civil War. If such are erected, it shall be unlawful for the authorities of the locality to disturb or interfere with any monuments or memorials so erected, or to prevent the citizens from taking proper measures and exercising proper means for the protection, preservation and care of same, according to the statute. In this case, the statute states that disturb or interfere with includes the removal of, damage to, or defacement of such monuments. However, Moore wrote, the plaintiffs in the lawsuit have not sufficiently shown that the Lee statue is a monument to the Civil War. In the court's view, plaintiffs do not plead any specific fact to establish the statue as a monument or memorial to the war between the states, American Civil War, Moore wrote. Plaintiffs argue that it is common knowledge who Robert E. Lee is. That may be, but does not resolve the issue. Nothing in the pleadings or attachments makes any reference with regard to the Lee statue, to the war between the states, the Civil War, or to any other war, for that matter, or to him being a veteran thereof, he wrote. Moore will give the plaintiffs 21 days to amend the facts presented in their pleading and to refile the complaint. In conclusion, Moore wrote that the case will not be dismissed and that a previously ordered injunction of removal of the statue will remain in effect unless the plaintiffs do not file an amended complaint within the 21 days or do not ask for an extension. Also in court Wednesday, S. Braxton Perrier, an attorney for the plaintiffs, argued that the city should not be allowed to cover the statues with tarps because it interferes with the injunction by depriving the public views of the statues. Perrier also said the city's decision had nothing to do with mourning those killed and injured in the aftermath of white supremacist violence on August 12. It's a thinly veiled, no pun intended, attempt to justify interference, Perrier said. They're not trying to mourn anyone's loss, they're just trying to interfere with the statues. Perrier also argued that the tarps could leave the statues with irreparable damage. If moisture gets trapped beneath the tarps, he said, the metal in the statues could corrode. He also argued that, if there is significant wind, the tarp could act as a sail, and the statue could topple over. Every minute those covers are in place is harmful, Perrier said. They're an embarrassment to the community. It's not a shroud, it's a trash bag, he said. Lisa Robertson, deputy attorney for the city of Charlottesville, entered a motion to strike all of the evidence presented by the plaintiffs. I don't believe there is an irreparable harm likely to happen to either the statues or the public if they remain covered until this is resolved, Robertson said. Like it or not, since the covers have gone on, things seem to have calmed down. Instead, she said, the issue of the tarps could be addressed at a later date, once the lawsuit has been resolved. The Daily Progress News app keeps you up to date. Click here to get the free iOS or Android app. Sign up for breaking news emails and contest alerts. Click here to sign up. Perrier argued back that the shrouds were never put up with the intention of protecting the statues from vandalism, such as spray paint, which has occurred multiple times since July. Moore said the plaintiff provided enough evidence to withstand the motion to strike and allowed their evidence to stand. Robertson also called City Manager Maurice Jones to the stand, who said that since the tarps have gone up, No damages to the statues have been reported by city officials. Parks and Recreation employees periodically check on the statues, Jones said, but have not reported any cracks in the metal or masonry or any mildew due to moisture. He also said the city had no plans to specifically check for such problems. In the end, Morsetti would not extend the injunction past its expiration date in November. Morsetti would extend the temporary injunction to include the Jackson statue because the city council recently voted to remove it once the lawsuit is resolved. Moore also expressed his concerns about the tarps, particularly about unknown risks of damage to the statues, but said he would not require the city to remove them. "I don't believe the plaintiffs have carried the burden of irreparable harm to the statues," Moore said. "And I'm still taking the city at its word that these covers are temporary. I'm also concerned the city does not care about the condition of the statues under the covers," he said. "But I'm not going to enjoin the city to remove the covers."